Every conversation carries a consequence. Every viewpoint searches for facts. Discovering your legal standing, delivering rightful justice.
Sir, can I see your papers for this car?
May I ask the legal basis for this? I'm not committing any violation.
We've got a string of luxury car thefts in the area. High-end vehicles. I'm District Judge Denzel Blackwell. My credentials are right here.
Judge Denzel Blackwell was fueling his Mercedes when Sheriff Brian Colton pulled up behind him, lights flashing. Blackwell wasn't breaking any laws. He was a federal judge about to become the victim of the most expensive racial profiling case in Texas history. What the sheriff didn't know, 4 cameras were recording everything. The man he was handcuffing could send him to prison. The briefcase he was about to break into contained sealed federal documents, and his actions would trigger an investigation ending in 47 years behind bars and $33 million in damages. If you are ready to see institutional racism taken down, like this video and drop a comment telling me where you're watching from. And if this is your first time here, hit that subscribe button right now because you won't want to miss tomorrow's story of cops messing with the wrong people and finding out. Let's continue. Judge Denzel Blackwell was 48 years old. He had graduated from Yale Law School, summa cum laude, clerked for Supreme Court Justice Sotomayor, spent 15 years as a civil rights attorney, winning cases that changed state law, and been appointed to the federal bench 6 years earlier after a confirmation process so thorough it had included interviews with his childhood teachers. He presided over cases affecting millions of lives. He had the authority to hold government officials in contempt of court, issue arrest warrants for federal crimes, and seal indictments that could topple criminal organizations. His decisions set legal precedent across multiple states. On this particular Thursday afternoon in June, Blackwell was driving from the federal courthouse in San Antonio to a judicial conference in Austin. Personal vehicle, black Mercedes-Benz S-Class he'd purchased after years of careful saving from his federal salary. Texas plates clearly visible. He wore a tailored navy suit, crisp white shirt, the small federal judiciary lapel pin on his jacket collar that identified him to those who knew what to look for. He pulled into a gas station off Highway 281. Nothing unusual about the stop. He'd driven this route dozens of times. He swiped his credit card, inserted the nozzle, and watched the numbers climb on the digital display while mentally reviewing his afternoon schedule. That's when Sheriff Brian Colton of Kendall County pulled into the station behind him. The gas nozzle clicked off precisely as Blackwell noticed the patrol vehicle. He removed the nozzle, replaced it in the pump cradle, and reached for his receipt. Blue and red lights flooded his peripheral vision. The sheriff's vehicle had positioned itself directly behind the Mercedes, blocking any exit. Blackwell's mind shifted immediately into the analytical mode that had served him through hundreds of courtroom battles. Time, 2:47 p.m. Location, Highway 281, approximately 40 miles outside San Antonio city limits. Witnesses: woman fueling an SUV at the adjacent pump, teenager in a pickup truck across the station, gas station attendant visible through the window. Sheriff Colton emerged from his patrol vehicle with body language that spoke of authority assumed rather than earned, hand hovering near his service weapon, shoulders tight, jaw set in an expression that suggested decisions had already been made. The command came sharp and immediate. Blackwell turned slowly, deliberately. His hands remained visible at his sides, movements controlled and unthreatening. He had litigated enough civil rights cases to know how quickly these situations could spiral into violence. He spoke in the measured, authoritative tone that commanded federal courtrooms. The sheriff's expression didn't change. Blackwell reached slowly into his inside jacket pocket, announcing each movement as he made it. His fingers found the leather credential case that held both his Texas driver's license and his federal judicial identification. He produced both documents and extended them toward Colton. The federal credentials were unmistakable. Official seal of the United States District Court embossed in gold. Photograph. Full name, Denzel Robert Blackwell. Title: United States District Judge, Western District of Texas. Lifetime appointment designation. Security features that prevented forgery. Colton examined the credentials for approximately 5 seconds. His eyes moved from the photo to Blackwell's face, then to the Mercedes, then back to the credentials. His expression remained unchanged, skeptical and hostile in equal measure. What he said next would cost him everything. Blackwell felt something cold settle in his chest. He had spent his entire legal career fighting against exactly this kind of institutional arrogance. He maintained his composure through sheer professional discipline. The sheriff's hand moved fractionally closer to his weapon. Blackwell calculated his options. Argue and risk escalation. Comply and preserve evidence for later action. His legal training provided the answer immediately. Document everything. Maintain calm. Use the system designed for exactly this situation. At the adjacent pump, the woman had pulled out her phone. The recording light was visible even from 15 feet away. Across the station, the teenager in the pickup truck had his phone pressed against his window, camera aimed directly at the confrontation. Above them, 3 security cameras captured different angles of the scene. Inside the Mercedes, Blackwell's dash cam recorded audio and video through the windshield. Blackwell turned around and placed his hands behind his back. The handcuffs clicked onto his wrists with unnecessary force, tightened beyond what restraint required. The metal bit into skin. Other customers had stopped their activities entirely, frozen in various states of shock and confusion. The atmosphere had thickened with tension that was almost physical. Colton radioed for backup. His voice carried across the station, professional bureaucratic language that completely misrepresented reality. Suspicious individual. Potentially fraudulent credentials. Possible vehicle theft. Blackwell stood in handcuffs next to his legally owned Mercedes and said nothing. His mind was already 3 steps ahead, cataloging violations, identifying applicable federal statutes, constructing the legal framework that would bring consequences for what was happening. Deputy James Thornhill arrived within 8 minutes, younger than Colton by perhaps a decade, clearly deferring to the senior officer's authority without question. Blackwell explained the situation again, voice calm and precise. Federal judge, legitimate vehicle registration, travel from courthouse to conference, every detail easily verifiable through multiple channels. The 2 officers conferred briefly, glancing repeatedly at the expensive Mercedes as though the vehicle itself constituted evidence of wrongdoing. They approached the car together, peering through the windows at the interior. On the passenger seat sat Blackwell's leather briefcase, embossed with the federal court seal in gold lettering visible even through the tinted glass. Colton returned to where Blackwell stood in handcuffs. Blackwell's response was immediate and unambiguous. He cited the Fourth Amendment, explained that no probable cause existed for any search, warned specifically about the briefcase contents. His voice carried the weight of judicial authority, even from a position of physical restraint. Colton dismissed the warning with a gesture. Exigent circumstances, he claimed. Reasonable suspicion of criminal activity. The legal justifications were paper-thin and both men knew it. Thornhill appeared uncertain, hesitation visible in his body language, but he followed Colton's lead without verbal objection. What happened next would transform a civil rights violation into a federal obstruction case. Colton retrieved tools from his patrol vehicle and forced open the locked briefcase. The leather tore. The lock mechanism broke. Inside, multiple manila folders lay stacked in careful order. Each folder bore stamps in bold red letters, sealed by order of federal court. The documents included witness statements under protective order, confidential investigative materials from ongoing federal cases, evidence in matters that affected national interests. One file, thicker than the others, carried a label typed in precise legal formatting. Civil Rights Class Action. Kendall County Sheriff's Department. Neither officer read carefully enough to understand what they were looking at. Colton pulled out his personal phone and began photographing pages. The camera shutter sound clicked repeatedly in the quiet afternoon. Thornhill hesitated for perhaps 10 seconds, then followed suit, photographing different sections of the documents. From the patrol car, Blackwell watched through the window. His face remained impassive, but his mind documented every detail. Each photograph created metadata, each image stored in cloud backup systems, each action building a permanent, irrefutable evidence trail. He stated the facts clearly. The photographs continued. Colton's justification was brief and dismissive. Evidence gathering for the vehicle theft investigation, he claimed. The documents were returned to the broken briefcase. Blackwell was loaded into the patrol vehicle's back seat. The plastic was hard and uncomfortable. The cage, separating front from back, created a physical barrier that matched the legal chasm opening beneath Colton's feet. The drive to Kendall County Sheriff's Department took 18 minutes. Blackwell sat in silence, mentally reviewing federal statutes. 18 U.S.C. Section 242, Deprivation of Rights under Color of Law. 18 U.S.C. Section 1503, Obstruction of Justice. 18 U.S.C. Section 271, Interference with Federal Judicial Proceedings. The charges were stacking themselves in his mind like legal dominoes, each one carrying mandatory minimum sentences measured in years. They arrived at the Sheriff's Department at 3:14 p.m. Processing began immediately. Fingerprints, photographs, property inventory. Blackwell complied with every procedural requirement while his mind tracked the time. His judicial assistant expected a check-in call at 3 p.m. sharp. It was now 3:14. The federal machinery was already beginning to move. At 3:05 p.m., Judicial Assistant Rebecca Torres attempted to reach Judge Blackwell by phone. The call went directly to voicemail, which was unusual enough to register concern. Blackwell was known throughout the Western District for punctuality that bordered on obsessive. He returned calls within minutes. He confirmed appointments hours in advance. He had never, in 6 years on the bench, missed a scheduled check-in without prior notification. Torres waited 10 minutes and tried again. 3:15 p.m. Still no answer. At 3:18 p.m., she activated the protocol. The call went to Deputy U.S. Marshal Felix Rodriguez, who handled judicial security for the Western District. Rodriguez had protected federal judges for 14 years. He understood immediately that this wasn't administrative oversight. Federal judges operated under specific security protocols precisely because they made decisions that affected powerful people. Threats were constant. Protective measures were mandatory. Rodriguez accessed the tracking system for court-issued devices within seconds. Blackwell's phone had last pinged a cell tower on Highway 281 at 2:53 p.m. The location data placed him at a gas station 40 miles outside San Antonio. No movement since. The Marshal team dispatched within minutes. They arrived at the gas station to find Blackwell's Mercedes, still parked at pump number 4, driver's door unlocked, keys missing, no sign of the judge. Rodriguez reviewed security footage on site. The recording showed everything. Federal judge in business attire, sheriff approaching with aggressive posture, credentials presented and examined, handcuffs applied, briefcase forced open, documents photographed, judge placed in patrol vehicle and driven away. At 3:32 p.m., Rodriguez called Kendall County Sheriff's Department directly. The desk sergeant checked the system with routine efficiency, subject in custody matching description, brought in approximately 20 minutes earlier. Rodriguez asked for the charges. The sergeant read from the computer screen. Suspected vehicle theft. Fraudulent impersonation of a federal officer. The silence on the marshal's end stretched long enough to become uncomfortable. When Rodriguez spoke again, his voice had changed completely. Each word carried the weight of federal authority mobilizing in real time. The sergeant's tone transformed instantly. Fear replaced bureaucratic routine. Within seconds, the desk sergeant was pulling up Blackwell's intake record, confirming the judicial credentials that should have prevented the arrest entirely, and summoning every supervisor on duty. Captain Ellis Freeman had been with Kendall County Sheriff's Department for 22 years. He'd handled corruption investigations, officer-involved shootings, federal audits, and budget crises. Nothing in his experience prepared him for what the desk sergeant told him. Freeman reached the holding area within minutes. Judge Blackwell sat on the concrete bench, suit jacket folded beside him, tie loosened but still knotted, posture upright despite the degrading circumstances. Freeman's prepared apologies died in his throat at the sight of absolute judicial composure in a holding cell. Blackwell looked up. His expression was neutral, professional, and utterly controlled. Freeman's hands were already moving toward his keys, but Blackwell stopped him with a single question. The captain checked the evidence log. His face drained of color as he read the inventory notation. Briefcase contents photographed for evidence purposes. Officers Colton and Thornhill, Blackwell asked his second question. Freeman confirmed what he was reading. Multiple sealed federal court documents accessed and photographed. His hands had begun to tremble visibly. Blackwell delivered his third question. Freeman identified both officers from the evidence documentation. Colton had photographed 43 pages. Thornhill had photographed 21 pages. The metadata was all there, timestamps accurate to the second. Blackwell stood. He straightened his suit jacket with movements that suggested courtroom rather than cell. His voice remained measured and judicial. He explained what Colton and Thornhill had done. Violated federal court seal on protected documents. Accessed confidential materials without authorization. Created permanent digital evidence of obstruction. Then he paused deliberately before revealing the detail that transformed everything. The documents pertained to active civil rights litigation against Kendall County Sheriff's Department. Class action lawsuit alleging systematic racial profiling, falsified arrest reports, and constitutional violations spanning years. Freeman's expression cycled through stages, concern to horror to comprehension of complete catastrophe. Blackwell continued with the same professional calm. He was the presiding judge on that exact case. The officers had illegally accessed sealed evidence from litigation where their own department was defendant. They had photographed witness statements, investigative findings, and confidential materials. They had created permanent digital records of federal obstruction via phone cameras connected to cloud storage systems. Freeman attempted explanation, apology, damage control. The words came out stammered and desperate. Blackwell cut him off with judicial finality. Release would be immediate and complete. All personal property returned. Phone, briefcase, vehicle keys. No further processing. Then he stated what would happen next. Formal complaints would be filed with multiple federal agencies. He listed them systematically, each name carrying the weight of institutional authority. United States Marshal Service. Department of Justice, Civil Rights Division. Fifth Circuit Court of Appeals. Federal Bureau of Investigation. Think about this for a moment. Sheriff Colton thought he was dealing with a car thief. Instead, he'd just handed a federal judge documented evidence of obstruction, civil rights violations, and tampering with sealed court proceedings. Do you think Colton would have acted differently if Judge Blackwell had been white? Drop your thoughts in the comments below. Blackwell left the sheriff's department at 3:47 p.m., exactly 1 hour after the initial stop. He drove the Mercedes directly toward San Antonio, phone already connecting through hands-free system. The first call went to U.S. Marshal Rodriguez. Blackwell provided a detailed account while maintaining highway speed, every relevant fact delivered in precise chronological order. Rodriguez listened without interruption, already initiating federal response protocols. Blackwell arrived at the federal courthouse at 4:23 p.m. He proceeded directly to his chambers, bypassing the public areas where his disheveled appearance might raise questions. Once inside the secure space, he began making the calls that would trigger institutional response. Chief Judge Patricia Ramsey of the Western District took his call immediately. Blackwell briefed her comprehensively, voice steady, despite the events of the past 2 hours. Ramsey's response was immediate and unequivocal. Full federal investigation, mandatory. Resources unlimited. Consequences severe. The Department of Justice Civil Rights Division call came next. Senior attorney on duty. Blackwell provided timeline, identified violations, mentioned the photograph sealed documents. The DOJ attorney recognized implications instantly. Federal obstruction, tampering with judicial proceedings, civil rights deprivation under color of law, investigative team deployment promised within hours. Final call went to Fifth Circuit Court of Appeals Administration. Blackwell explained why he must recuse himself from the compromised civil rights case. Circuit Administration agreed immediately and assigned replacement judge within the hour. Meanwhile, federal machinery moved with precision, honed by decades of protocol. U.S. Marshals executed preservation order at Kendall County Sheriff's Department. All electronic devices seized. Phones, computers, servers, body camera footage. Evidence preservation extended to cloud storage accounts, email systems, and personal devices used for official business. Colton and Thornhill were placed on immediate administrative leave. Freeman received orders to compile all documentation related to the incident, every report, every log entry, every communication. Federal investigators arrived at 6:15 p.m. Department of Justice attorneys, FBI agents, U.S. Marshals. They began comprehensive evidence collection with methodical efficiency. Gas station security footage obtained, 4 angles covering the entire interaction, witness statements taken from bystanders who'd recorded the confrontation on phones. The woman from the adjacent pump provided her video file, voice still shaking with outrage at what she'd witnessed. The teenager submitted his footage, which included clear audio of Blackwell identifying himself as federal judge. Investigators noted multiple constitutional violations visible in the recordings: false arrest, illegal search, unauthorized access to sealed federal documents, each violation documented with timestamps and witness corroboration. The forensic team downloaded photographs from Colton's phone. Metadata showed 47 pages of sealed documents photographed between 2:58 and 3:06 p.m. Cross-reference with case files revealed devastating pattern. All 47 pages came from the Kendall County civil rights lawsuit, but the final revelation was worse. Among the photographed pages were witness statements, detailed allegations, systematic profiling, falsified reports, constitutional violations, and the witnesses were describing Sheriff Brian Colton by name. He had photographed evidence of his own misconduct while committing new federal crimes. The irony was perfect, the evidence permanent, the consequences inevitable. Federal forensic analysis revealed scope that exceeded even the investigators' initial expectations. The Computer Crimes Unit spent 6 weeks examining Colton's devices, cloud storage, and communication records. What they found was a systematic pattern spanning 12 years. Database queries showed 538 traffic stops initiated by Colton since joining the department. Demographic breakdown revealed 89% involved minority drivers in a county where census data showed 67% white population. Statistical analysis proved profiling beyond any reasonable doubt, numbers so extreme they couldn't be explained by anything except intentional targeting. The investigation expanded to arrest outcomes, 89 arrests that were later dismissed or overturned. Patterns included falsified probable cause in police reports, allegations of planted evidence, coerced confessions documented in court filings that had been systematically ignored by department supervision. 23 formal complaints had been filed against Colton over his career. Every single complaint had been dismissed internally without proper investigation. Department supervision records showed warnings flagged by the system, patterns identified by software algorithms, all overlooked through what could only be described as deliberate institutional blindness. Text messages between Colton and other deputies revealed culture that went beyond individual misconduct. Messages mocked minority drivers with racist language, celebrated arrest quotas as achievements, shared memes that violated every principle of equal protection under law. Thornhill's involvement was confirmed through message participation and matching stop patterns. 4 additional deputies were identified as participating in the profiling network through communication analysis and statistical correlation. But financial forensics uncovered something that transformed the case entirely. Colton had been selling confidential information, mugshots, arrest records, personal data from law enforcement databases. Tabloid websites and bail bond companies had paid him $127,000 over 8 years. He had created systematic revenue stream from exploiting the very people he arrested, many of whose arrests were later proven false. Federal charges compiled by Department of Justice prosecutors began with 12 counts. Additional evidence expanded the indictment to 41 federal counts total. Deprivation of rights under color of law, obstruction of justice, tampering with federal judicial proceedings, computer crimes, wire fraud, conspiracy, falsifying government records, each charge carrying mandatory minimum sentences, many with maximum penalties measured in decades. The trial convened 8 months after the gas station incident. Federal courtroom in San Antonio, presided over by a judge brought in from outside the district to ensure impartiality. Prosecution presented overwhelming evidence across 3 weeks. Video footage showed the gas station stop from 4 angles. Forensic data documented the photograph's sealed documents with metadata precision. Statistical analysis demonstrated profiling patterns that defense couldn't explain. Victim testimony brought human cost into sharp focus. Judge Blackwell took the witness stand and testified for 6 hours across 2 days. He described the gas station stop in precise detail, voice never wavering, judicial composure maintained throughout. He explained the significance of sealed federal documents, the protocols designed to protect them, the severity of violations when those protections were breached. Cross-examination attempted to discredit him but failed completely against credentials that were unimpeachable and demeanor that remained perfectly professional. Other victims testified to pattern of abuse. Woman who lost her job after bogus arrest, employment record permanently damaged by charges later dismissed. Elderly man thrown to ground during pretextual stop, injuries requiring hospitalization, young father who missed his son's birth because Colton jailed him on fabricated charges that were dropped weeks later. Statistical expert testified that 89% minority stop rate in 67% white county was mathematical impossibility without intentional racial targeting. Computer forensics specialist walked jury through metadata, cloud backups, deleted files recovered from devices. Financial analyst detailed $127,000 in illegal payments traceable through banking records. Defense attempted arguments about reasonable suspicion, department training protocols, isolated incidents taken out of context. Prosecution systematically dismantled each claim with documented evidence that proved pattern, practice, and intentional misconduct. The jury deliberated 4 hours before returning verdict. Guilty on all 41 federal counts. No acquittals. No hung jury on any charge. Colton sat without visible emotion while his attorney appeared devastated. Separate proceedings sentenced the others. Thornhill received 18 years federal prison for accessory charges and obstruction. 4 other deputies received sentences ranging from 6 to 12 years each. Department supervisor received 8 years for systematically covering up complaints and enabling the profiling network. Colton's sentencing hearing was held 6 weeks after verdict. Federal guidelines recommended 35 to 40 years based on conviction counts and criminal history. But prosecution argued for upward departure from guidelines. They presented victim impact statements from 23 individuals whose lives Colton had damaged. They documented systematic abuse spanning more than a decade. They emphasized racial targeting as civil rights violation affecting entire communities. Defense pleaded for leniency, family circumstances, claimed veteran status, expressed remorse that seemed performative given the evidence of celebration in text messages. Judge Teresa Villanueva presided, federal judge known throughout the Fifth Circuit for strict constitutional adherence and unwillingness to tolerate government misconduct. Her sentencing speech addressed the systematic nature of violations, the betrayal of public trust, the damage to community faith in law enforcement. She noted special severity of obstructing federal judiciary. Photographing sealed court documents wasn't just crime, it was assault on the judicial system itself. She emphasized how racial profiling pattern represented civil rights violation that affected not just individual victims but entire communities forced to live under discriminatory enforcement. Judge Villanueva pronounced sentence: 47 years in federal prison, no possibility of parole under federal sentencing guidelines. Colton would be 88 years old before release eligibility. Effective life sentence. All pension benefits revoked. Law enforcement certification permanently stripped. Appeals filed to Fifth Circuit and denied. Petition to Supreme Court denied without comment. Every avenue of escape closed. The civil lawsuit proceeded on parallel track. Blackwell v. Kendall County Sheriff's Department. Claims of false arrest, civil rights deprivation, intentional infliction of emotional distress, systematic failure of supervision. County attempted quiet settlement. Offered $2.8 million with non-disclosure agreement attached. Blackwell refused. He demanded public trial and institutional accountability that settlement would obscure. Civil trial lasted 3 weeks. Jury heard evidence of systematic departmental failures that had enabled Colton's behavior for over a decade, supervision that ignored warnings, complaint processes that dismissed allegations without investigation, culture that encouraged profiling through informal reward systems. Verdict came back decisively. $33.7 million in damages. Largest civil rights settlement in Texas history. $8.7 million compensatory damages. $25 million punitive damages specifically designed to punish the department for deliberate indifference to constitutional violations. Federal consent decree was imposed. 7 years of Department of Justice monitoring and required reforms. County forced to implement independent oversight board with subpoena authority. Mandatory body cameras with footage stored by independent third party. Bias training redesigned by civil rights experts. Early intervention systems to identify problem officers before patterns became entrenched. All stop data tracked by demographics with quarterly public reporting. 3 weeks after civil verdict, Judge Blackwell held press conference. He announced creation of Blackwell Legal Defense Foundation funded by entire settlement amount. Foundation mission centered on funding appeals for wrongful convictions and providing legal aid to those unable to afford representation. The foundation established judicial accountability training program that was adopted by 14 states within 2 years. It achieved remarkable success. 17 wrongfully convicted individuals freed in first 2 years of operation. Legal aid provided to hundreds of defendants facing charges similar to those Colton had falsified. Blackwell returned to federal bench and continued serving with distinction. The case became teaching tool used in law schools across the country for civil procedure and constitutional law courses. FBI incorporated it into civil rights training for agents. Judicial conferences cited it as example of maintaining composure under extreme duress and using institutional authority appropriately. The story concluded with reflection on how single act of racial profiling had exposed 12-year criminal enterprise. The system had worked, but only because documentation was preserved. Authority was asserted through proper channels, and institutions responded as designed when confronted with undeniable evidence. Final image crystallized the transformation. Colton in federal prison, stripped of authority and freedom, serving sentence that would end only with death. Blackwell in judicial robes, continuing to administer justice from bench with same composed authority he'd shown in handcuffs at a gas station. Sometimes justice isn't just served. Sometimes it's delivered with 47 years of interest and a $33 million receipt.
If you like this video, make sure to hit that like button, subscribe, and turn on the notification bell so you don't miss the next story. Share this video with someone who would appreciate it, and let's keep building this community together. And before you go, drop a comment below. I'd love to hear your thoughts on what stood out to you the most. Until next time, stay safe, stay curious, and I'll see you in the next.
Justice requires constant vigilance, and credible information is your best defense. Thank you for watching and fostering a transparent society.